SJC-12948, Governo Law Firm, LLC, v. Kendra and Bergeron and others.
And Attorney Fleegoff, we'll start with you.
Thank you, Your Honor, and good morning, Your Honors. Kurt Fleegoff, I represent the plaintiff appellant Governo Law Firm. We're here because the trial court made 3 errors below. The first error was with respect to the jury instructions with respect to our 93A claim. I apologize. The court erred because it instructed the jury that the defendant's conversion of the Governo Law Firm's property was irrelevant and could not be considered with respect to the issue of whether the defendants engaged in unfair or deceptive business practices. Secondly, the trial court erred with respect to its order where he declined to order the defendants to return all of the property that they had converted from the Governo Law Firm. And third, the trial court erred with respect to interest, both pre-judgment and post-judgment interest. Turning to the jury instructions, the trial court ordered that with respect to 93A, any acts prior to November 20th, 2016 was in fact irrelevant and could not be considered by the jury. The November 20th, 2016 date was significant in the court's mind because that was the date in which the individual defendants terminated their employment from Governo Law Firm. The conversion of the Governo Law Firm's property occurred prior to that date, prior to November 20th, 2016.
Counsel, do you, excuse me for interrupting, do you have a date that you would be comfortable with other than the 20th? Would you peg it at November 1st when it was incorporated?
The conversion occurred in October and November of 2016. So both before and after the incorporation of CMBG3. And
what about the last sentence of the instruction? The last sentence reads, instead for this claim, the Governo firm must prove the defendants did something to compete with the Governo firm after they left that firm that was unfair. So if they used something they took prior to, I mean, I understand, say they were just caught in the act of stealing this stuff and fired. I understand that wouldn't be a 93A claim.
Yes, Your Honor.
But if they walked off with it and then a month later started using it to compete, doesn't the last sentence cover that of the instruction?
But the prior part of that instruction dictates that the jury cannot consider the fact that the property had been converted. The jury was required to consider the fact that they used property without consideration as to how the defendants came to obtain that property. So they were not allowed to consider the fact that the property in fact had been stolen, which occurred again prior to November 20th of 2016.
Well, I thought in part that you wanted that change because you wanted to be able to support a 93A claim in terms of their conduct. It was somewhat separate from this count that the money damages were won on. Was there not another count or a claim you were looking to support with that evidence?
Well, we certainly we had a claim for a conversion and we put that evidence in and we prevailed on that. The jury found as a matter of fact that the defendants had converted the property of the Governo Law Firm. Our position with respect to the 93A claim is that it was a 93A violation for the defendants to have used the converted material in competition with the Governo Law Firm. And as instructed by the jury, by the judge, the jury was not allowed to consider the fact that, in fact, the property had been converted.
Mr. Fleegoff, I agree with you that the word irrelevant was erroneous because obviously the jury needs to understand the circumstances in which something was taken from the firm and in order to be able to evaluate whether later the action was unfair or deceptive. So the word irrelevant, it seems to me was clearly error. But going back to Justice Kafker's point, if you look at everything else surrounding that erroneous instruction, isn't it clear that he's just trying to instruct on Manning versus Zuckerman and the understanding that the conduct can't be an employee actions against an employer during the employment?
I do believe that that's what the judge was trying to get at. However, that was erroneous for three reasons. First, with respect to CMBG3, which was a defendant that was found to have converted the property. Again, the conversion happened prior to November 20th. CMBG3 never was an employee of the Governo law firm. So the Manning case simply does not apply with respect to CMBG3. There was no reason to provide that instruction for.
Is that because you're saying that the employees of the plaintiff firm were, while they were still employees, agents of the defendant?
The jury found that the defendant CMBG3 independently converted the property of the Governo law firm. So, I mean, did they do it through the agents? Yes, that's the way it happens, but that's what the jury found.
Okay, all right.
So with respect.
So I agree with you that Peggy Lawton, or whatever that case is the correct law, that if you stole something, like, I mean, the example is the secret recipe. You're the baker, you steal the secret recipe, and then you go out and start a new bakery. I get that should be a 93A violation, but I just don't know if the judge, I mean, the instruction is, as Justice Lewis said, shouldn't have had the word irrelevant, but is it good enough for government work here to convey that they can still sue for that later activity?
It's not, Your Honor. The key to our case was the fact that the material that had been stolen was used in competition. And as instructed by the court, the jury was not allowed to consider the fact that the property had been stolen. The jury was required to consider the fact that from the jury's perspective, with respect to the 93A claim, it was as if they had found it on the street or found it sitting on their desk, and that there was nothing wrong with the fact as to how they had obtained that material. That's the way the judge instructed the jury.
Counsel, can I clarify then your position? Your position is that the 93A claim involves both the theft and the use, and that by instructing that the theft was irrelevant, it undermined the ability of the jury to reach that part of your claim.
Yes, Your Honor.
Okay.
Yes, Your Honor. So it was erroneous, again, with respect to CMBG3, clearly, because Manning simply doesn't apply. With respect to the individual defendants, again, as just articulated, our claim was that they used converted material and the jury was precluded from considering the fact that it had been converted. Additionally, with respect to the individual defendants, we went back, we looked at Manning. The Manning case says that 93A does not apply to acts arising out of the employment relationship. There is no authority in Manning or in any other case law, and there's certainly nothing in the 93A that provides that business competitors who happen to also be employees receive blanket immunity from Chapter 93A. The legislature did not intend that. There's a Connecticut case that considers a similar statute with respect to Connecticut law that says, again, that you need to have, it needs to be trade or business, the Larson case. And that court said that if you are acting outside the scope of employment, that there can be liability.
Can I shift you, because the other two issues are huge too. Can I shift you to the second issue? Because my sense is the legal community is most concerned about what can be taken and what can't and how it can be used afterwards. That's the, particularly law partners are moving around law firms all the time.
Yes,
and they're leaving with their files. So what did the judge describe the ruling? Because I'm not sure I fully grasp what the jury found there was some improper conversion. And that's not even being appealed from what I gather.
Correct.
But what did the judge allow and disallow afterwards as precisely as you can? Because that's a huge issue to the bar.
Yes, Your Honor. That was the entire defense of the defendants at trial, and they lost that.
I understand that the jury, I'm not sure I thought that was, I'm not sure that's so clearly a jury issue, but that's beyond us at this point. So I'm just trying to understand, what did the judge do? Okay, he found improper conversion, but he allowed some of it to be retained and some of it not. What did he allow and what did he disallow? Because that's important.
Yeah, yes, Your Honor, thank you. So what the judge did was we moved for a permanent injunction after the jury's verdict, and we asked that the defendants be required to return everything that had been converted. And the court in its decision said the defendants have no right to hold on to the electronic materials that they improperly took. He then drafted his order.
Well, hold it, but from what I understand, some of these are client files, some of these aren't. And it's not too obvious to me what's permissible, what's not. But then and it's not all water under the bridge, because we are dealing with this issue of what he allowed to be kept and what he required to be returned. But you keep talking about the electronic files. You need to be a little more specific to be helpful here.
Certainly, Your Honor. First, to be clear, separate and apart from the material that had been converted, the Governo law firm transferred all of the client files that the defendants were entitled to have.
Before you answer that, can we just maybe establish some terms? I think that might be helpful. When you talk about, you're really talking about the database, the client files, and the administrative files, correct?
Yes.
You've got three kinds of electronic files we're talking about. And right now, you're talking about the client files.
The Governo law firm transferred the client files over.
Right.
Our issue with the court's order is that the court did not order the defendants to return what we call the administrative files. So these are the Governo law firm's contact lists, notes concerning clients, client billing history, employee handbooks, those types of things. Things that have nothing to do with the client files. The court simply, we thought he had just made a mistake and had overlooked the fact that the administrative files were also among the materials that had been converted. We raised it on a motion for reconsideration. We asked the court to include that in its order. The court denied it, but didn't provide any explanation, didn't make any findings of fact as to why that material should not also be returned or deleted. So we say that that is an error as well.
So in Justice Cipher's terminology, the three categories, I thought we were fighting over the second category, not the administrative one, not the client files, but the third category of this kind of, history, sort of this. Are we just talking about billing records and, your employee handbook? Because the bar is not going to be focused on that going forward. Are we talking about a lot of their research files and other things here that are?
I apologize, Your Honor. The court ordered all of that material to be returned, and that has not been appealed.
And that would be called the data file, right? The database file,
et cetera. Yes, that was ordered to be returned. We have no issue with that. All we're talking about is the administrative files, separate and apart from the client files, or what might conceivably be a client file. Turning to the interest issue.
So I'm sorry,
well, before you,
can I clarify this one more time? So in the words that you use in your brief, the A500 file, the asbestos historic folder, that has been ordered returned, right?
Yes, Your Honor.
Okay, the databases have been ordered returned, right?
Yes, Your Honor.
All right, so all you're talking about is the administrative file, which is like the standard operating procedures, the billing history. That was not ordered returned, and we don't know why.
Correct, Your Honor.
All right, but you're not asking for current client files that clients have directed you or your client to change to the new firm.
No, all that has been.
You're not asking for that?
That's not an issue.
Okay.
That's not an issue.
All right.
I need one more clarification before you move on too, please. As it relates to the administrative files, you touched on this. Are you saying that this was inadvertent when the injunction issued, that the administrative files weren't being returned?
Well, that's what we believed, and we moved for reconsideration on that basis. And the judge, I don't know why, but the judge did not change the order and let it stand, simply saying that he had discretion, but making no factual findings as to why he should distinguish this one category of material from others.
All right. You're going to go to the pre and post judgment.
Yes, Your Honor. So with respect to pre-judgment interest, the trial judge vacated the award of approximately $267,000 worth of pre-judgment interest. And in doing so, he relied upon old case law, the USM case and the jet spray cooler cases. After those cases had been decided, the legislature amended the statute, chapter 231, section 6H, which now provides that in any case where damages are awarded, there must be pre-judgment interest.
So I think that's the problem, though. What is damages? Here you disgorge profits.
No, respectfully, no, Your Honor.
Okay.
Here, our damages were measured by the benefit that the plaintiffs received. They are still damages to the Governo law firm. And if you look at the Curtis Wright case, they expressly define that calculation as, in fact, damages.
But pre-judgment interest is meant to compensate the prevailing party for the time value of the money accrued between the time for the resolution of the legal dispute.
Yes,
and here, I thought that $900,000 was based on a calculation from November 20th to date of trial. So there was no time delay. It's built into the 900,000, isn't it?
Yes, Your Honor. That's how they were measured. But they are still, that is a measurement of the government. It is a way to get at what the Governo law firm lost. It's an acceptable way to measure damages to the Governo law firm.
Built into that calculation is that time that normally pre-judgment interest would be.
Correct. That is the method by which the damages were calculated, but it is an approximation for what the Governo law firm lost. And therefore they are damages. Again, Curtis Wright expressly describes them as damages, and per the statute, all damages are to get interest. And this court has said that it is in the Herrick case, it's a catch-all interest provision. And in the George case, the legislature's intent is that pre-judgment interest always is awarded in a case of compensatory damages.
Counsel, if it's all right with the Chief Justice, I have one more question. I know we're running close on time. And can you tell me how much, if any, precedential weight we should give Judge Young's decision in the Federal District Court on the interest statute?
Well, I mean, obviously it's not binding, but I think it is convincing. He looked at the statute. He saw that the statute had been changed by the legislature and saw that the prior decisions of this court cannot stand in light of the amendment to the statute.
Did he discuss in any way the meaning of the term damages versus this profit?
He recognized, I believe he recognized, I don't think he expressly said it, but he recognized again that these are damages that are being awarded to the plaintiff, and therefore you get pre-judgment interest.
Thank you.
Then turning to the post-judgment interest, what happened is the defendants refused to release the amount of the judgment to the governmental law firm and instead deposited it with the court. The whole point of post-judgment interest is to benefit the plaintiff for the loss of use of the money. The defendants refused to pay that money over to the governmental law firm.
I thought you didn't want to accept it.
We wouldn't accept, they made it contingent. They said they would provide us with the money, provided only contingent if we abandon our appellate rights, which we're not willing to do.
Does anybody have any other questions about the post-judgment interest?
I would just add that the amount that was deposited also was $35,000 less than what should have been deposited in any event. So thank you, Your Honors. With that, we just would ask that you would remand this matter for a new trial with respect to 93A. You instruct the trial judge to order the deletion of all the property that had been converted. You instruct the trial court to award pre-judgment interest and post-judgment interest. Thank you, Your Honors.
Thank you. Attorney Carr.
Yes, good morning, Your Honors. I appreciate your time. Let me just say, We did not appeal. I represent CMBG3 and the individual attorneys in this case. I appreciate your honors hearing us today. We did not appeal. And so I'm stating that out front. The issue is whether or not I'm going to start with the injunction. Judge Salinger crafted that injunction based upon the trial evidence that was heard by the court for the duration of the case. With respect to the administrative files, your honors, there was no evidence that those files, administrative materials, which I understand now we're just focusing on the administrative materials. I didn't understand that from the briefing, but now I'm understanding that from the argument this morning. There was no evidence that the administrative materials, generic handbook, generic billing procedures, and the evidence was, your honor, the Governo law firm created the handbook, for instance, by taking information off the internet, created the billing procedures from other firms that other people had been at over the years. So those materials.
Counsel, doesn't the administrative file include contact lists, client contact lists?
Your honor,
Essentially a trade secret, no?
I don't believe the evidence was that all the administrative files as broadly defined included client contact lists, but client contact lists are not confidential and proprietary business information of the Governo law firm. And that was what the purpose of the—
Why? Can you explain that one? Because that's inconsistent with every trade secret case I've ever heard.
Well, the court in Meehan had said, in this court in Meehan way back when, said that part of the duty of an attorney departing was to notify clients that they are departing, and that the contact information of those clients need to be provided to the departing attorneys so that they can communicate with the clients that they are departing.
So are you suggesting the administrative file is only the current client contacts of the departing attorneys?
No, I'm not even certain, as I sit here today, what is the quotes administrative files of the law firm, other than they describe the handbook, the billing procedures, the internal operations of the firm, how to bill, how to put time down on a timesheet. And Mr. Governo at trial conceded that that information was derived from the internet, from public sources of information. And so when Judge Salinger determined whether or not the permanent injunction should extend to information that was not confidential and proprietary, there's no abuse of discretion there. Judge Salinger determined that the plaintiff had not established a need for permanent injunctive relief. And this court in Light Lab said, hey, there's no evidence that there's no evidence of future reoffense. The injunction was proper, was in the court's discretion to fashion the order. Here, so if we're focusing only on those administrative materials, there's no reason to upset that injunction that Judge Salinger entered. With respect to the client file materials.
So sticking with the administrative file, are you suggesting that if I look in the record, there's going to be a finding with Judge Salinger saying that the administrative files, whatever they may constitute, are not confidential?
No, the judge did not make a specific finding in entering the order. I'd have to go back and read the order on the injunction. It's in my addendum, but the plaintiff had the burden to prove why it was entitled to an injunction to protect these broad swaths of information that it claimed was its property. It claimed that it owned the client files. It claimed that it owned all the information about ongoing clients. And so therefore all of that should be enjoined. And it also claimed that its confidential and proprietary business information included, for instance, just as an example, the employee handbook. And there was no evidence in the record, the trial record, to substantiate that that was confidential and proprietary business information to permit an injunction as an additional equitable remedy for the misappropriation claim.
Was that not part of the conversion finding by the jury?
No, because there's no evidence, Your Honor.
I ask you then to turn to the 93A jury instruction. Why is that not erroneous? Because as Your Honors had indicated, if you want to say the word irrelevant is erroneous, I'm not going to fight what Judge Salinger constructed only from this perspective. I want to address that point.
The word irrelevant is relative to assessing trade or commerce. What Judge Salinger was stating is that the conduct that occurred during the course of the employment is not relevant to the assessment of trade and commerce. And that's Manning, that's Sala, that's all the cases from this court that says inter-entity conduct is not trade or commerce. So that's what the word relevant, irrelevant was referenced to when you read the instruction.
But I mean, I understand everything that's around the instruction, but that I don't think when the jury is told, hey, so anything that happened before X date, that's all irrelevant to the 93A claim. I just don't think they took it that way. Now I think afterwards he does make the point that only consider unfair and deceptive practices after they left the firm. And so it's juxtaposed, I believe, against that. But to say that everything that happened before they left is irrelevant, that has to be error.
Well, Your Honor, I don't read the instruction that way, Your Honor, because the judge said specifically that if you find that the use of the copied materials was used for competitive advantage after they left, you may find that there was an unfair deceptive practice. And that's what the case was about. It was the use of the materials to compete after they departed. That was the case.
But isn't it important that the material arrived at the new law firm improperly?
And nobody restricted the evidence from going in on that point. The whole case was.
No, but I guess to Judge Lowy's point, Justice Lowy's point, isn't it important that the employees took this confidential information while they were employed, i.e. before November 20th, and by instructing the jury that they could not consider that, that caused the jury perhaps to misconstrue the subsequent use?
Your Honor, I disagree with that from this perspective. As I read the instruction, the court was instructing on the element of trade or commerce. That's an essential element because this count went to the jury, and so the jury had to first determine, was this trade or commerce? And the
How do you respond with regard to the new firm? The new firm.
I'm sorry, I didn't hear you.
I know. The new firm is not an employee.
Absolutely.
Why is the new firm pre-November 20th conduct not relevant?
The new firm didn't operate until after my clients left on November 20th. The evidence was undisputed in that point.
But isn't that really, counsel, isn't that really, I don't mean to interrupt Justice Wetland's, the answer to her question, but isn't that really the point here? That conduct, that there could actually, the cases say, oh, that's an employee-employer relationship, so we're not going to look at trade secrets and all that stuff. But really what was happening is you might not have been active. You were incorporated by November 1st, but everybody was acting in concert for the benefit of the new firm before leaving Governo. And so that can color, even though they're still technically employees, doesn't that color the 93A claim?
Your Honor, yes, it does. But the jury wasn't precluded from considering that evidence on unfair or deceptive practices after they left. The jury can't consider that information on trade or commerce. That's the distinction I'm trying to make. The element of trade or commerce.
What part of the instruction should I look at for your trade or commerce?
That's where that irrelevant language arises. It's with respect to the first element. As the court went through the instructions, the court said the first element you need to determine is trade or commerce. And it said by law, an employee-employer relationship. If you look at the instructions, it says conduct is part of.
What page are you on the instructions in your appendix?
So my addendum, Your Honor, if you get, it's actually in my brief excerpted at page 15.
Yeah, no, I'm looking at the entire, whatever's in the record, and which is on, submitted was page 157, and then it jumps to 158, and then it jumps to it goes forward. But where in that stretch is the section you're talking about?
It's at addendum page 120, 123.
Okay, and it's not the paragraph you're referring me to, right? Not the
I'm
paragraph.
looking at, if you look at the bottom of one addendum 120, it starts with one more claim to talk about. It's a 93A claim. The court goes on to prevail on this claim. The Governo law firm had to prove two things. First, that the defendant did something while acting in trade or commerce that was unfair, deceptive, and second, unjustly profited.
Okay.
As to the first element, they must prove something was in trade or commerce. And then the court goes on to talk about and instruct on trade or commerce.
Can you tell us where in the instructions? Because I thought the only saving grace was the sentence after the irrelevant one. Is there somewhere else where Judge Salinger makes clear that if they stole it earlier and used it later, that could be considered? Where do we turn in the instructions to clarify that point?
So Judge Salinger goes on to say, instead, for this claim, the Governo firm must prove that the defendants did something to compete with the Governo firm after they left that firm that was unfair or deceptive.
Yeah, you see, but that's,
so
yeah, but Mr. Carr, just to clarify, that's what I thought was all the same. If that's all you got, how do they do what you're talking about? Because they've just been told that everything before this is irrelevant. So they need to do something unfair and deceptive afterwards, but they're not told that that the use afterwards is relevant.
It says right here, Your Honor, it's the next paragraph.
Go ahead, read it to me.
He says, so given the evidence in this case, and again, this was based on the evidence and the arguments of the plaintiff that their case was about use to compete when they left. That was their case. So Judge Salinger says, so given the evidence in this case, the Governo firm must convince you that the defendant used confidential information or documents belonging to the Governo firm to compete against that firm in an unfair or deceptive manner, and they did so after their employment at the Governo firm ended.
Okay, so you feel that clarifies the irrelevant mistake?
Absolutely, because then he goes to talk about the element of unfair, deceptive even further, Your Honor. So Judge Salinger goes on after that to then again define the elements of unfair, deceptive, and he doesn't use that language relative to, quotes, irrelevant. So it's clear that he's instructing the jury, and this was an important part that I raised, frankly, at the charge conference and wasn't even addressed by the plaintiff. I was concerned about the arising out of employment relationship that everything that occurred arose out of. I was preserving my appellate rights on that issue. And Judge Salinger said, look, I disagree, Mr. Carr. If they used the materials that they copied, and the evidence was that they copied the materials before they left, there was no fight about that. But if they use those materials after they leave, I think that that does not arise out of the employment relationship. I'm going to instruct the jury that they can say that if they use those materials that they copied, because the court had already given all the instructions on conversion, on misappropriation, on trade secrets, those instructions had been given prior to the 93A charge. And so if you read the whole, you got to read the charge as a whole and say, okay, the judge is saying that if you find that the information my clients copied before they left was confidential and proprietary information or trade secrets of the firm, and they did that in a manner that was a violation of law, that can be an X claim. And if they use that information, that can cause damages. And then they went on to describe the 93A piece of that whole theory of the case. There was no way that the plaintiff was precluded or prejudiced in any way from the jury understanding that the copying and use, those two things combined, was the case. And that was the whole theory. And so what Judge Salinger was concerned about, and this came up during the charge conference.
Mr. Carr, I haven't had a chance to read the closings. Are the closings fighting over that point that, basically the Peggy Lawton point? Okay, if they stole it and they used it, that can be a 93A violation. Is that clear in the closings?
But I don't recall, Your Honor, but I do recall this, that the plaintiff wanted the jury to use all of the other so-called bad acts of preparing to start a new firm as a 93A violation, as part of the unfair deceptive practices of planning to compete with Governo. And that's what that led the court to say, don't consider the negotiations about the buyout. Don't consider that they were opening a new firm or that they were planning secretly to leave, because none of that can be a 93A claim. The plaintiff, in closing, my recollection is they talked about all these so-called bad acts that my clients engaged in addition to the copying. And so they wanted the jury to focus on everything. And if you look at the request for relief in this brief, if you look at, they specifically ask you to remand to permit all evidence of pre-departure conduct, including the copying, not just the copying, including the copying, to be considered as part of an unfair deceptive trade practice. So they want you, Your Honors, to say that plans to leave and compete and start a new law firm can be part of unfair deceptive conduct, not just the copying. And that was the argument that they argued to the jury, that you can consider all of what they did to secretly plan to meet. And you saw, they reference in their brief the so-called, bad conduct towards Mr. Governo. That was what the Judge Salinger was trying to avoid, was the undue prejudice to the defendants, if you will, that the jury would consider all that other conduct as part of trading commerce and as part of unfair and deceptive acts, as opposed to, yes, they copied the materials. Is it if jury had to first decide, is that Governo property or not Governo property? And then they use that.
Mr. Carr,
Yes, sir.
I'd like to get your take on the prejudgment interest, because we're over already. Justice Wendland's point seems to me compelling, that, and different from anything that's been argued, or even what Judge Salinger wrote, which is that the way you calculate this disgorgement, it basically builds in the time value of money. That's real to me. That seems to be a narrower distinction, but one that's sensible, because just because you measure damages by disgorged profits in general doesn't seem to preclude prejudgment interest. But here, it seems like the amount builds up over time, so it takes this into account. So isn't that the way we should analyze the prejudgment interest point?
I agree. That's one way. And I think when I cited to jet spray in my motion to my JNOV to amend the judgment to remove prejudgment interest, I relied on jet spray in part because that was part of the analysis. I've understood jet spray to say that is the damage, if you will. And so therefore you can't get interest on interest, to Your Honor's point. I'm saying it a little bit differently, but it's the same concept, because these are disgorged profits of what my client earned on the misuse of the materials, not harm, not damage sustained by the firm. So they're not deprived of that money during that period of time because they never earned that money during the period of time. But to the extent that they're being compensated through money, it's the same concept. That's the amount of money that, if you so-called quotes, were deprived, it's the same deprivation of use. And so therefore the prejudgment interest statute, if you will, I don't think it applies. I really don't. I don't want to cede that point, because there's no way that, in my estimation, based on this court's decision in the George case, that not every payment of money is damages. It's got to be compensatory damages. And these are disgorged profits. This is unjust enrichment. And the appeals court, and I believe this court has held before, including in national merchandising, which goes way back a long time ago, that there's a bright line distinction between damages and disgorgement. And so if this court says—
The problem is all the lawyers left, right? So he doesn't have any ability to—
That's not accurate, Your Honor. That's frankly, that's not accurate. That is not true. All the lawyers initially did not leave. There were still people working there, including Miss Kelly, who stayed behind, who was originally part of the group. So not to interrupt, Your Honor, but what happened was my clients left and the clients chose to leave to go with them. And there was no evidence. The court directed out the breach of fiduciary duty claim on solicitation because there was no evidence of unlawful solicitation. So the clients exercised their rights to choose my clients, and there were lawyers remaining at Governo law firm. And so the answer is they could still earn a living. It's just these clients chose to depart, and they have a right to do that. But so either Your Honor, on Your Honor's understanding, which I agree with, that amount of money serves the purpose, if you will, of prejudgment interest, or the same statutory reason for that as the court has interpreted the prejudgment interest statute, or it's not damages under the George case, where everything that's a money payment is not a damage subject to prejudgment interest. And there should be no prejudgment interest.
Do you think the legislature was contemplating that?
As I understand the way this court has interpreted statutory construction time and again, is that the legislature is supposed to know, or does assume to know, there's a distinction between money damages and disgorgement, which is rooted in our law for many, many, many years. So when the legislature wrote 6H and used the word damages as opposed to monetary recovery, which I would then probably not have a really strong argument on the compensatory damage piece, but I still agree with Your Honor that it's still within the rubric of prejudgment interest. I would probably not have that same argument, Your Honor. So the legislature is presumed to know the current status of the law when it drafts a new statute. It knew jet spray. Jet spray is still a bedrock case from this court. It's still cited throughout, and so therefore they know what the distinction is between disgorgement remedy and damages.
Anybody have
one question? Yes, and that's just Justice Kafka referred to the closing argument. Can you tell me, are the closing arguments reproduced in the record appendix?
My recollection is they are.
Okay, thank you.
Do you, Your Honors, I didn't address because I'm over. I wanted to answer your questions. I don't know if you want me to address the post-judgment interest issue or not. Otherwise, I rest on my brief on that, and I appreciate Your Honor's time and ability to answer your questions. So thank you very much.
Thank you.
Excellent. Thank you very much, counsel.